Hello, everybody. Thank you so much for coming today and joining us really for this great opportunity that we have here on Lānaʻi. The Keiki Network is very honored to have our distinguished guests here with us today and sharing their areas of expertise within the judicial system. The Keiki Network has been planning this community workshop for months with the purpose to bring more information and resources about the judicial system to our community. I'm going to go over just a few ground rules. First, in respect to our presenters, please turn off your cell phones, put it on vibe. If you have to take a phone call, please feel free to do so. Just take it outside. The presenters will be presenting, and then there will be a Q&A, questions and answers after each presentation. So we'll allow you guys to ask questions at that time. Our presenters are here to share information with us. This is not a courtroom. Please keep your questions and concerns objective and not emotional. Please respect all questions and concerns. If you disagree with anyone, please do so with respect. And finally, just please one speaker at a time. It is my great pleasure to introduce our guests today. And I'm going to start off with Honorable Judge Lloyd Pullman. And he has been practicing law in Hawaii since 1992. He moved to Maui in 1994 and established the law partnership of Pullman and Lānaʻi, where his practice included personal and business law, personal and business litigation, personal injury litigation, bankruptcy, property law, property disputes, estate planning, general legal counseling, and was a per diem judge for family court. And then in 2013, he became a full-time family court judge for the Second Circuit County of Maui. In his spare time, he enjoys canoe paddling and tries to remember to relax and stay centered with regular Tai Chi and yoga practice. Next, we have Brandon Siegel, and he is a deputy prosecuting attorney with the Department of the Prosecuting Attorney. He is currently the supervisor for the District Court Division. District Court has jurisdiction over all traffic infractions, violations, petty misdemeanors, and misdemeanor level offenses. Brandon is a graduate of the University of Hawaii and the William S. Richardson School of Law, and he has lived in Maui for the past 3 years. Prior to joining the prosecutor's office, Brandon was an associate attorney specializing in commercial litigation at the law firm of Alston, Hunt, Floyd & Ng in Oahu, and also clerked for Chief Judge Craig Nakamura of the Hawaii Intermediate Court of Appeals. And lastly, we have Honorable Judge Adrian Healy. Judge Healy is one of the 3 full-time district court judges for the Second Circuit serving Maui County. She presides over traffic, criminal, and civil cases. Prior to being sworn in as judge in 2012, Judge Healy served as the Deputy Corporation Counsel for the County of Maui, advising the mayor, council members, and various county departments. Prior to joining Corporation Counsel, Judge Healy was a private litigation attorney, a deputy public defender for the state of Hawaii, and a law clerk for Honorable Michael Tao. Judge Healy is very active in providing pro bono services within the legal community, as well as participating in civil service activities outside of the legal community, serving on multiple boards and work groups benefiting the greater good of her community. She also enjoys spending her free time outdoors with her family. Wendy Hudson, the supervising attorney of the Maui Office of the Public Defender, was supposed to be here today, but unfortunately at the very last minute could not attend due to a family emergency. So at this time, it is, again, please give a warm welcome to our guests. We are very thankful for them being here today and taking time out of your guys' very busy schedule. So thank you. So up first, we're going to have Judge Pullman, who's going to be giving his presentation in the realms of family court. And again, after his presentation, we will be taking questions and answers.
Good afternoon, everyone. I'm really happy to be here, and I'm happy to see you here. All right, can you click my first slide? I want to say thank you. And then you go back to the thank you. You're a little fast.
Sorry.
The other thing I have on this slide is a picture of an iceberg. And we just had a meeting this afternoon with our KP network that you folks have here on Lānaʻi. And if you're not familiar with them, they're a group of a lot of different agencies that deal with children and families, child protective services, mental health, a lot of different agencies. And we've had a meeting with them earlier today where they were able to ask specific questions regarding how things work. The reason we have this meeting today now is to open ourselves up to any questions that the community might have, and also explain what the family court does, what the district court does, and how the prosecutor's office in regard to criminal matters interplays with mostly the district court, and how the criminal process also works. On the left side of that photo is a picture of an iceberg, and that kind of reminds me of the Keiki network, which is, you only see the tip of the iceberg a lot of times, that these people are really doing a lot of good work. And all that they do doesn't always come to the surface. And the little bit that does come to the surface is very small in comparison to all that they do. I expect most of you in the community are the same way. Most people work, and to me, working is volunteering in a way. You do get paid for it, but that's what makes this whole world work, is that people are willing to show up, they're willing to do a job, and a lot of the time when people do a job, it goes unrecognized. You're the lower part of the iceberg. So I just wanted to take a minute to say thank you to the Keiki Network, thank you to the community, and thanks for inviting us. Also, at one point, if it's okay, I wanted to try to take a photo so we could maybe get it information back to Honolulu, and it might possibly appear on the Judiciary's website. And so if you're uncomfortable, try not to be in the photo, but I'd really appreciate it if we can have a photo, because it might help us be able to get something like this happening again, if we can show, it puts a face to what we've done. Next slide. Family Court meets on Lānaʻi 6 times per year on the even months, February, April, June, August, October, and December on the 3rd Thursday. So it's only once every 2 months that we're actually physically here on Lānaʻi. We also have hearings on Lānaʻi without the judge being here, and I'm the judge that usually comes over here to Lānaʻi, and I've done it for the past 3 years since I've been a full-time judge, and I also did it part-time as a per diem judge too, I also believe. We also attend court in Lānaʻi by Polycom, where we have a live feed video that goes between Lānaʻi and Maui. We also do the same type for Molokai. That's why I'm mentioning them sometimes. When we have restraining order hearings or child protective service hearings, some hearings have to be set very quickly. And on those hearings, we will often do the initial hearing by Polycom, and then any contested hearing or further hearings usually happen after the initial hearing here live on Molokai. Next slide, please. The question is can it possibly be more often here on Molokai? I'm sorry. On Lānaʻi. Can it be held more often? The Judiciary is committed to servicing all the islands with the family court presence, and I've been working with Judge Kawano as well as the other judges trying to get funding for a new judge position that we could have as a split judge position between district court and family court, with the emphasis of that judge focusing on the outer districts, Lānaʻi, Molokai, Hana, Lahaina, and have it so that courts can be held more often. Now, when you have a new judge position, that also means you need more clerking staff. So the only thing holding back this from happening is there's just limited resources in the state. There's only so many tax dollars and a lot of people going to the legislature trying to get funding. But I believe our day will come where we'll be able to have more regular court here on Lānaʻi, and that's definitely a goal. Next slide. In the meantime, other than when the times the court does appear here, there is access to justice on Lānaʻi, but it's somewhat limited. One is the Judiciary's website, which if you did a Google search for Maui or courts, Hawaii, you would get the Judiciary's public website. And on that public website, you would find forms, the forms you could fill out for divorces, paternities, different types of actions. When I get to the next slide, it will say all the different types of things the family court handles. Many of those there are pre-prepared forms, fill-in-the-blank forms that you can get on the website. The other thing we have available is the Service Center on Maui at the Wailuku Courthouse. That has a volunteer attorneys on Thursdays from 9 a.m. to 12 noon. And I meant to put the phone number up on that slide, but I didn't get it in there. If you're on Lānaʻi, you can call in. And I've got that phone number. I'm going to get it in as part of the tape, but I don't have it right in my hand. Or if you want to talk to me afterwards, I'll get you that number. And so if you call between 9 and noon on those Thursdays, you'll get a volunteer attorney who can help you know what forms you need to fill out and what you do with the forms. The other thing we have available, if I can have the next slide, there's a lot of co-parenting resources. This would be for paternity cases and divorce cases. And if you do basic Google searches, you can get information about how to co-parent. If I could have the next slide. I've also spoken or sent an email to the director of the Maui Mediation Services, and they will service Lānaʻi. They can handle with landlord-tenant disputes, they could handle divorce issues, they could handle custody issues, and she committed to me, their director said that yes, we will fly a mediator over to Lānaʻi if you have work over there to do. And that's the reply email. Aloha Judge, yes, we are able to provide services on Lānaʻi. Next slide. These are what family court handles. This, other than I have one more thank you slide, so I'm just going to stay as this is my last slide. So I'm open to answer questions in regard to these areas. I cannot give you any specific answers in regard to any specific case, but generally how the process works on any of these topics. These are the court calendars that the family court handles. We handle divorce, paternity, child protective services, juvenile law violations, family court, drug court, which includes child protective services and juveniles. That we don't have right now on Lānaʻi though. We have child support enforcement cases, collection of child support, establishing child support. That can also be done through the Child Support Enforcement Agency. Either the family court or Child Support Enforcement Agency can help establish child support. Department of Education cases, when kids are missing school, then petitions can be filed, and then we'll serve the parents and the kids to come to court, and we can follow up their school attendance to make certain they get back on track to not missing school, seeing if there's any barriers in the way with them getting to school on time. We also do family court temporary restraining orders. Judge Healy, she handles restraining orders also. Hers are more like neighbor disputes. The family court handles the disputes that are between household or family members, people who are related by blood, people who have been involved in a romantic relationship, or people who have children in common. Or if somebody's living with their girlfriend and she's staying at dad's house, that's more like a family situation rather than, oh, they're roommates, just economically sharing a household. Roommates would belong in district court now, but the rest of the family court restraining orders we handle in family court. We also in family court do guardianships of minors, guardianships of incapacitated persons, adult protective services, which is like a child protective services but for older citizens usually, or citizens that are incapacitated. We also do involuntary commitments. That would be if somebody is committed to Molokini, mental health wards for a period of time. They have a right to a hearing, they have a right to contest their commitment, and the judge needs to make specific findings. And the court also handles, family court also handles adoptions, and we periodically handle weddings. But the rest of the stuff is the other stuff. If you have any question, I'm open for those now. And if there aren't questions, I'm going to go to the next person. And if we have time at the end, I do have a little more I could talk about on co-parenting too. If we had any extra time, that's another thing I want to talk about. But yes.
Judge, regarding mediation, Do you, as a family court judge, ever order mediation? This is a two-part question. So that one, first of all, do you ever order that
All the time.
all the time?
Yep, and now that I've heard that Maui Mediation Services will handle it on Lānaʻi, I expect it's going to happen more often. I don't want it to slow down the track of how quickly we get a decision if there can't be an agreement, because a lot of the mediations involve families with children, and when there's children, I don't like to have those situations lingering unresolved, because it's stressful on the parents, not knowing exactly what the court might order regarding, for example, parenting time, with what parents should they be with more of the time or less of the time, or how should they split that up. And when parents are stressed out, the kids are stressed out. So those I like to get figured out as soon as we can without too much delay. The easiest way would be if the parents can come to an agreement. And I encourage that because they're going to be dealing with each other for years and years to come. And if they can get on the track of figuring it out by working together as opposed to coming to court and having some third party judge stranger figure it out for them, I think that's the better track. But if they can't figure it out, I definitely want the court to be a resource that's available without too much delay. But if we do the mediation, what I expect will happen is we'll have the mediation ordered, and then the next 2-month cycle when we come back, the mediation will have happened in the between time. If there is an agreement in mediation, then the court can sign an order adopting the mediated agreement. And if there's not an agreement, then the court then could set it for a contested hearing. Or a lot of times when they come back, sometimes just with a conversation with the parties, we can identify what are the issues, what aren't you able to agree on. A lot of times when people actually identify their issues and speak a little about where they're coming from, we're able to massage an agreement there in court without having to have a contested hearing, which is a track I do like to get it on for the reasons I said before. People are working together then, and we get a quicker decision. You had a two-part question. I went on
I
and on.
do, thank you. So if the court orders mediation, who pays for it? And if the court doesn't order it, who pays for it?
All right. Maui Mediation Services is a nonprofit organization. They charge a fee, but it's really small for the service you get, especially if they're paying the airfare to get a mediator over here. They're not going to be charging you that fee. I would say it's probably around $50 total for both sides to come in based on most people's income. So it's a nominal fee, but there is a fee there. If it's a third party mediator, like sometimes, there's some psychologists on Maui who will handle mediations on custody cases, or some professional mediators, or sometimes attorneys will act as mediators, and they will charge more than Maui Mediation Services usually. Sometimes they might have a fee of around $1,000 retainer or something like that, to get started. But if it's a big, ugly, contested divorce case with custody issues, property division issues, sometimes it's well worth the money to follow through with the mediators that are do it more professionally. But I will say, whatever mediators we get over here on Lānaʻi will probably be their top tier mediators, and it likely might even be a volunteer attorney as a mediator.
So even if the court orders it, it's the party's responsibility to pay for it?
Yes, yeah.
And I think it's a
What that
sliding
fee.
scale fee, at least it used to be.
Yes, it is a sliding
Okay.
scale.
Thank you.
Yeah. Hello.
What's the cost on the paternity test?
If you want a paternity test, one way you could go about that would be to contact Child Support Enforcement Agency, and if you can get them to start the paternity action, I think they have a contract price that's a little better than if you come as private parties to the court and file a paternity action. And if you come as private parties, the court doesn't have that resource. It's not like we have a center, but I will ask the parties, who do you propose to do the testing? And I think diagnostic laboratories, if they don't do it, they have a place they can refer. But I think the fee depends on which service does it, which lab does it. But I think it can be around $150 to $200 for the.
So then they go according to per child?
Yeah, each child would need its own genetic test.
So just as a follow-up on that, I'm sorry, were you done? Did you
Yeah.
Okay. Where was I going with that? If like we were talking earlier, if the parent is receiving financial support from the state gets involved in that paternity. So, let's say I have a child, baby daddy is disputing it, I'm receiving food stamps and welfare, so child support comes in. Who pays for the paternity test then?
It will be fronted by Child Support Enforcement Agency. The state will front it, but then they might, as part of the paternity order, if paternity is determined that he is the father, then they might order, once it's determined, one or both of the parties to pay the fee.
Thank you.
But if they turn out not to be the father, then you don't have to pay. Unless it's a private company, and then they're going to collect either way. Okay.
Judge Coleman,
Yeah.
I know you said in the earlier slide you come to Lānaʻi 4 times a year for family court. Or six
Six, yeah.
times a year, sorry, but can you explain to them how many family court judges are there and what are you doing the rest of the time?
Oh, when we're not on Lānaʻi? Okay. In the Second Circuit, which is what Maui County is. So if you ever go on the court to find, on the website to find court forms, look for the Second Circuit, but I think it identifies it by county. Second Circuit has 3 family court judges. We have Judge Richard Bisson, who handles criminal family court domestic assaults, abuse of household or family member criminal prosecutions. And he also handles circuit court calendar, so he's kind of a split family court, circuit court judge. And then there's also Judge Keith Tanaka and then myself. We are the other 2 district court family court judges, and Judge Tanaka and I are only focused on family court, and we handle all of the things up there. The one that Judge Bisson. Oh, you know what? I don't even have his calendar up there, I don't think, because I was just thinking of my own world. So that's the other thing the family court handles, is criminal prosecutions of abuse of household or family members. And then the rest of these, Judge Tanaka and I split. And right now I'm handling all the divorces, all the paternities. He's handling the child protective services. We split the juvenile law violations. He's handling family court, drug court. I usually do the child support enforcement cases because I have the divorce and paternity. He handles Department of Education, something school. He handles the restraining orders. I handle the guardianships of minors and incapacitated persons and the adult protective services. We split the involuntary commitments, and I do the adoptions. But when I go to Lānaʻi or Molokai, I handle all of the calendars, which is one reason I really like coming here, is because it's a great refresher course on all the calendars I don't normally handle. But we're both full-time. Most of our time is spent on Maui. Good question.
This morning we didn't talk much about juvenile offenders. Can you talk about how family court handles juvenile offenders differently than you do adult offenders?
Okay. The law violation, the criminal law violation, is generally the same statute, except juveniles can commit crimes that adults can't. That would include like possession of alcohol, curfew violations. So those types of violations are called status offenses, and that's based on their age. And the other offenses are by the criminal statute, and if they commit those, it depends on the level. But the way it works is there is an adjudication, is what they call it. That's what arraignment. So in juvenile court, we have, they try and use softer, gentler language. For example, instead of guilty or not guilty, the question is, do you admit or deny? So the process is pretty much the same as an adult. You'll have the first day you come to court, you call it the arraignment, and we call it the adjudication. And we'll ask them if they admit or deny, and if they deny, then we'll set it for a pretrial. And I'll tell them at the pretrial, they're going to be there, usually most qualified to have the court appoint a public defender to represent the juvenile. And if they don't, they have a right to hire an attorney, but most of them qualified for a court-appointed attorney. And I'll tell them, you're going to come back on this pretrial date with your parents, and your attorney is going to talk with the state's attorney and see if they can work out an agreement that you agreed with, because you have to agree to it also. And if you can't work out an agreement, then it will be set for a trial date. Most cases settle by the pretrial level stage, but if they do go to a contested trial, then it would be a bench trial. The judge would listen to the testimony. That would be like me, and the prosecution would have the burden of prove the case beyond a reasonable doubt. The juvenile, with the help of their attorney, will be able to cross-examine witnesses, challenge the legal admissibility of the testimony and the exhibits, will be able to put on their own defense with the help of their attorney, call witnesses, present exhibits, decide whether or not they want to testify or not themselves. Then we'll have a process. If you've seen a trial on TV, it's very similar. There'll be closing arguments, and then the judge will make a decision. If there is the word isn't convicted, so if the court finds that the state met their burden of proof, then there are consequences. So I don't call it a sentencing, I call it, you need to come back for your consequences. And there's a new program that's just started in the state. The legislature funded this program where all the juveniles now will go through a screening, and a computer program will, after responses received from the probation officer, will input the data, and then this program is supposed to explain what level of services are necessary. The theory being that over-servicing and under-servicing is a problem. You need the right level of services for the offense, and not only for the offense, but who that juvenile is as a person. For example, if they come from a real supportive family and they just got stupid with their friends, the level of service there that might introduce that juvenile to kids who are having, like, if they were ordered to go to an extensive alcohol program, for example, they might be introduced to an element that they would have been protected from. So over-servicing can actually be more detrimental than helpful to that type of a juvenile. But sometimes it might be a minor offense, but their family situation is real fractured. And so having a higher level of services for that juvenile actually would be a more positive thing. So they're trying to have the consequences actually be a productive thing, and to have the consequences match what will be most helpful to the juvenile. And the research says that this is a better way to go. The research says that if they use this tool, is what they call it, that there will be less monitoring, less consequences, less incarceration or custodies, is what they would call the juveniles, but that those who do need higher levels of services will get it. But I think time will tell, because it's new. It's new. It's just been started in the last few months.
Just to clarify, juvenile cases are confidential and not public record.
Correct. And it's under 18 years of age. Some juvenile cases we can keep monitoring after they turn 18 to make certain they pay restitution or have done their community service. We can keep monitoring, and the only difference then is their parents don't have to come back to court with them once they're 18.
I had the opportunity to sit with a parent who wanted support because English wasn't her second language when her son went through that process that you're describing. And granted, as you say, all the data isn't in yet, but it looks very promising. And I believe that as well, that depending on the level of care, just like we do with adult substance abuse, right? It's different level of care. And I just make that comment because I think about the consequences of having family court only once every other month. So a juvenile commits a crime today, and it might be next year before they actually get their consequences, right? And so there's, you know, why should I be doing good? Because I just might get away with it kind of thing, you know, that's kind of hard. But I'm hoping that that tool helps alleviate that, or help it somewhat. Not alleviate.
Let me comment on what you just said, which is, yeah, I think that you understand that the juvenile brain works differently than the adult brain, and they have a disconnect. They don't necessarily connect actions with consequences, and if you have too much lag of time. One of the possible downsides with this tool is that now it could have been that the juvenile would come to court, will admit, will plead to the offense, and in some of the smaller cases we would just have consequences right then. At least at the initial phases of this, every child needs to go through this tool. That will mean that we won't have the consequences right there on that day, and so there will be a lag. So in fact, this tool, rather than having the consequences more immediate, it stretches them out. And if they have a pretrial and then they change their plea, they're going to have to then have this screening intake, and then the screening intake results will make recommendations and then come back for those consequences, and then come back to show compliance. So the process actually has one more step required.
Okay.
So,
Okay, thank you for that.
Any other questions for Judge Pullman? Now's your chance. I know he said he'll be available after.
yeah.
Anyone else? Thank you, Judge.
Okay. And if we have more time,
Would you want to?
no, I just want to say.
We have some time if you wanted.
No, not now. But if we have time at the end, if we have any empty time, I do have more stuff I'd like to say, but
Okay.
not unless we have
Thank you,
time.
thank you. So next up will be Judge Healy, and I'll put your.
Yeah, I don't mind if Brandon comes with me too, since a lot of our topics are intertwined. But while you're putting our PowerPoint up, and I have extra copies if you wanted to pass it around, but. And we can stand or sit. But thank you so much, Kiki Network, Butch and Bev and Kelly and Susan. I tried to remember a few of your names for putting on this great community outreach seminar. It's first time, I believe, one of the sorts that ever been set up. So thank you. I know when Butch asked me when I was in court last year, December, of who KK Network could possibly contact. So I gave him a list of names. Our Chief Administrative Judge, Judge Cardoza for Maui, Second Circuit, our Administrative Director of the Court, Sandy Kozaki, also Head Public Defender, J.D. Kim, and Wendy Hudson, who's not here, as well as my immediate supervisor, Chief District Court Judge Kelsey Kawano. So besides thanking KK Network, I'd like to thank Chief Justice Rechtenroth and all those people mentioned for allowing us to come over here and meet and talk with you folks. It's a great opportunity to meet the community and answer questions that you may have. And I'm just really thankful and honored that you guys put it on. So, as Kelly said, I've been sworn in since 2012. And I have just a few slides to go through. I sometimes feel like Judge Judy and Jerry Springer all at the same time. I hear all kinds of cases, civil cases, TRO cases, traffic, criminal, as well as this past legislative session, or 2015, I believe. The judiciary or the legislature passed the environmental court. So in addition to traffic, criminal, civil, TROs, small claims, regular claims, we have to do environmental court, which handles hunting, gaming, fishing. And I just shared with Brandon a report that the Supreme Court Law Librarian put together for at least Second Judicial Circuit of how many environmental court cases that we've been having since its inception of July of this year. And at first they sent a report 8 pages long, with the Circuit Court having 4 cases. Circuit Court, we'll explain later what they do, but Judge Cardozo hears the environmental court cases for Circuit Court. One included the Stop Cane Burn, which is in the news. And the first report that had the numbers for District Court environmental court cases came back at 400-something cases since July. But 20 minutes later, the Supreme Court Law Librarian sent the report back and said, oh, I forgot the first half of the year. So the total number of EC cases for district court level. Second Judicial Circuit alone was over 1,000. So, and we have a very active DLNR, DOCARE, MPD agencies in those respective districts, especially with the hunting, permitting, fishing cases on our rural courts. But so we hear a lot of different types of cases at the district court level. And Wendy Hudson wanted to give her apologies for not making it, but she's the supervising public defender, and she said she really wanted to be here despite the family emergency. She was actually going to carpool with us over, so sorry she couldn't make it. But if you could go to the first slide, please. This is a disclosure, disclaimer. The PowerPoint was prepared by myself, and the views or opinions expressed by presenters are solely those of mine, and not necessarily those of the Judiciary, County of Maui, or State of Hawaii. I think I look a little bit like the one in the middle. And Brandon said, "Do I need a PowerPoint?" I said, "No, you could just do a question answer, and I don't want you guys to be too PowerPointed out. So we just wanted to be here to answer the questions that you may have and explain the process at the district court level a little bit." So I have a few pictures that I like to show, and we can skip this over because we did this morning. We introduced ourselves. And this is the main slide that when KK Network wanted to approach the judiciary to talk about certain things, they put a bullet point list of together. So I just cockroached that off of Butch's letter to the judiciary on the topics that you wanted to hear. So we talked a little bit about some of these, but I figured we will just go through each of those. And if you had additional questions about what kind of cases we hear, or any other questions regarding any of the district courts that we sit on, or areas that we sit on, then let us know. But the first bullet point was the progression after an arrest, and maybe Brandon can talk about that, and bail and bond differences.
Oh yeah, sure. So just to introduce myself real quick, my name is Brandon Siegel. I'm the District Court Supervisor with the County of Maui Prosecutor's Office. District Court is, like I said, it's anything from traffic infractions up through misdemeanor, maximum 1 year in jail. One of our biggest priorities in District Court is traffic safety, which you would know as DUIs or speeding, especially excessive speeding. That's the large majority of our cases that come through District Court, in addition to environmental court cases. The other typical type of Judge Judy cases, as Judge Healy mentioned, you'd see is shoplifting, disorderly conduct, harassment, things that are sort of neighborly disputes or small-time disputes between businesses and people in the community. But I am the supervisor for that division. We have 6 DPAs, including me, deputy prosecuting attorneys, and we're assigned to different courtrooms. 3C and 3D are district court courtrooms in Wailuku. 3C is, or 3D is A through M, and 3C is last names N through Z. And then we have 1 prosecutor who goes to Lahaina, Hana, here, and Molokai. But just generally, progression after arrest, bail, and bond, there's a number of ways that a case can come into our office. And so as a prosecutor, people ask, you know, what do the prosecutors do in relation to the police? Well, we partner with the police, but our mission is very simple. If you go to our website, it's just to promote justice. And so we do that by prosecuting crimes, and we promote justice through rehabilitation, punishment, deterrence, or if a person should not be prosecuted, we make that decision as well. But when someone's arrested for, say he's arrested for a DUI, generally bail is going to be set, and DUI is a petty misdemeanor, meaning generally a petty misdemeanor is a maximum 30 days in jail or $1,000 fine. For a DUI first time, it's actually only maximum 5 days in jail. But anything under 30 days in jail is considered a petty misdemeanor. So you don't have a right to a jury trial. You just have a right to a judge trial, and you stay in district court. If you have over 30 days, a possible sentence of over 30 days in jail up to 1 year, then you can go, you have a right to a jury trial, meaning you can ask the judge to move that to circuit court, which is a different judge, where your case would be decided by 12 members of the community. But when someone's arrested for a DUI, bail will be set. Normally for a DUI, it's $500 to $1,000, standard amount of bail. And if you can't post bail, then you're brought to court within 48 hours. And so if you're arrested here in Lānaʻi, say on a Friday, the next business day would be Monday. And the judge would have to sign a document called the Judicial Determination of Probable Cause, where the police officer would submit a document telling the judge what happened, and the judge would decide whether we have probable cause to hold that person, basically describe what he saw, whether the person had alcohol in his breath, and whether he blew a test at the station, and what his blood alcohol was at the time. If that is enough for the judge to find probable cause, then he'll be transported to Wailuku for what's called a custody calendar, which is normally 1 or 1:30, depending on the courtroom. At that point, then we can readdress bail, and he'll be appointed a public defender if he qualifies. Almost all of them do. And the public defender can make a request to reduce bail or have release on supervised release on their own recognizance, meaning that bail will not be required. A bond is very similar to bail. So say if the bail is $1,000, then you have to give the police $1,000. We say hold as security until your case is resolved. A bond you get through a bond company, meaning that you're going to pay them a fee. Generally, it's 10% of whatever the bail is, and they'll secure that bail to you for the court. So they're telling the court, we're going to make sure this person comes to court. But generally, the bond is better for the suspect because it's cheaper than the actual bail. It's only about 10%. And then I can go on a little bit after that, but that's generally the progression. After the arrest, either bail's set and they appear before the judge, or bail is not set and they're released, and third one is if you bail out, then you're given a court date, which is generally going to be 3 to 4 weeks after your arrest date. So you're not going to immediately appear before the judge.
And here in the Lānaʻi District Court meets every third Tuesday of the month. Well, my typical week looks like Monday and Friday, I'm in Wailuku handling civil as well as criminal traffic pretrial motion trial calendar. Tuesdays I'm traveling either to Lānaʻi, Molokai, or Hana for the rural district court calendars, master calendar, civils, TROs, landlord tenant, traffic criminal, and Wednesdays, Thursdays is traffic arraignment and pleas and criminal arraignment and pleas, as well as motion and trial calendar. So it's quite busy. And I also like to thank Judge Samashima, who's covering me. I'm supposed to be in Molokai today. He's covering that calendar for me today to allow me to come and speak here today. But I feel important that the community needs access to justice and to have a judge present in the community. And we talked about that a little bit more. And the reason why I asked Judge Coleman to explain what he does the rest of the other 360 days of the year, besides the 6 times he comes here on the 9, it's because we are very busy. There's 2 family court full-time judges, or 3. There's 3 family district court full-time judges. Circuit court, there's 4, I believe. Judge Cardoza, Judge Liu, Judge Bisson, and Judge Cahill. But to apply to be a judge, a district court judge, you have to be an attorney 6 years before you apply. To be a circuit court judge, you have to be an attorney 10 years before you apply, and then there's this whole different process with Senate confirmation, all these interviews with the CJ or the governor, depending which circuit you sit at. But we also discussed this morning how this past legislative session, there is the increase of the request to increase the number of district court judges from 3 to 4. The last time the statute was amended was in 1983, when it changed the number from 2 to 3. So we went to the legislature to ask for that, giving the support that our communities are increasing. With that, caseloads are increasing, and especially the rural court needs another judge out there to serve the community. So unfortunately, although it passed both House and Senate, the Ways and Means Committee didn't approve the judicial position for the changing the number 3 to 4 judges. And with that, not approving it, went 3 support staff positions and 2 clerk positions. So another opportunity for Lānaʻi County or Maui County to get another judge position and support staff position that would be perhaps open for any of the residents and community members here. But I explained a little bit, Brandon explained a little bit about district and circuit court as well, but I know that in the morning he talked about what's release pending investigation, so you want to touch on that
Oh, yeah.
briefly?
So release pending investigation, sometimes we get questions about that. It's shorthand as RPI. That's a designation that the Maui Police Department gives to a particular case. And say they're doing an investigation into an assault, and they've interviewed witnesses. They may have probable cause to arrest that person at that point, but they may decide that further investigation is needed. They may need to get a surveillance video from the store they were at, or they may need to interview more witnesses. And a person at that point would be released pending investigation, meaning that there'd be no charges at that point, and that MPD would do more follow-up on their criminal case. Maui Police are the ones who do the investigations. Our office does not do investigations generally on any type of criminal cases. So once they finish their case and finish their investigation, that's when that case is forwarded to us for prosecution. And so if someone is RPI'd, then if they're released pending investigation and it's forwarded to us for, say, a petty misdemeanor or misdemeanor, we would normally serve them by way of what's called a penal summons, which is just a document from the court saying you need to be here on a certain date. And if you're not, a bench warrant will issue for your arrest. So what we do is we file the complaint, and then that goes to the police, and they find that person and they give them a copy, they sign it, and they come to court about 3 weeks later after that. If it's a more serious case like a felony, then we can charge them either by the way of grand jury or by way of information warrant, which it depends on the severity of the case. There's certain cases that have to go before a grand jury and certain cases that don't have to go before a grand jury. But once the information warrant is submitted to the judge with all the information about the case, the judge signs off on the warrant if there's sufficient facts, and then the warrant is issued for their arrest to be brought to court to answer to the charges. And same with the grand jury. They hold grand jury once or twice a month. Those are confidential proceedings. The case is presented to the jury, and then if the jury finds that there's enough evidence to proceed, and the jury is made up of members of people like you, then the warrant goes out for the arrest and the charges are then filed. So that's generally release pending investigation. The other option is just release on their own recognizance, meaning we'll give you a court date, but you don't have to post bail. Bail is generally just a way, it's not meant to hold someone in custody, it's only meant to wait to ensure that they're going to come to court. And the bail is the factors for the judge is dangerousness to the community and likelihood of offense. So if a person has a history of contempt of court, history of missing court dates, generally we're going to set bail on that type of person. If it's a minor crime like a shoplifting, they're not a danger to the community at that point. So that will factor into whether or not they're going to have bail generally.
Thanks. The next bullet point talks about what's the differences between arraignments, pretrials, and trials and sentencing. Judge Pullman touched on it briefly, but arraignments are the initial appearances. The arraignment and plea is to inform you of the charge or charges against you. If the charge against you is a criminal charge, the judge refers the person to the public defender's office, who are constitutionally obligated to assist those that cannot afford an attorney and those who qualify for their services. When I say criminal charge, that means if there's a charge that subjects you to jail time upon conviction. Even driving without a license is a petty misdemeanor, but people think it's a traffic charge, but it actually is a criminal charge because there's possibility of that jail time upon conviction. So we refer anyone that's charged with the criminal charge to the public defenders. The public defender's office provides services free of charge to members of the public, paid for by the state of Hawaii, and they specialize in criminal defense. So we always recommend on arraignment and pleas of those who are charged with a criminal offense to speak to the public defenders before entering a plea. At arraignment and plea, someone can waive their right to an attorney or speak to the public defender, proceed pro se without counsel if the judge finds that they're making an intelligent decision. And then if the judge decides that they would ask the prosecutor to read or arraign the person, read the charge out loud, as well as explain the maximum possible penalties of that charge. And then you have your opportunity to enter your plea if you're ready. The judge also has to advise you of the important rights that you're giving up if you are pleading guilty or no contest. Also, most recently, a couple years ago, the legislature requires now the judges to inform all those pleading guilty or getting charged with a criminal offense to be advised of an immigration advisement and to make sure they're making an intelligent decision in making their plea Otherwise, if they're not a U.S. citizen, which we cannot ask your citizenship status, we have to advise them to research the issue of any consequences of getting a guilty plea upon the record. So that's called the immigration advisement, which in consequences are detention, deportation, denial of naturalization, or exclusion from admission to the United States. So those are certain things we have to advise the members of the public in traffic criminal court at arraignment and plea. There are 3 possible pleas after the charge is read to them and the penalties explained. Guilty, not guilty, or no contest. A guilty plea means that you believe you did commit the offense for which you've been charged and you're admitting to that charge. A not guilty plea means that you believe you did not commit the offense for which you've been charged and you are denying that charge. A no contest plea means that you do not want to contest the charge. You're neither admitting nor denying that you committed the offense for which you've been charged. But the courts usually explain, if you plead guilty or no contest, you're giving up all these rights. You're giving up your right to question, cross-examine the state's witnesses, the officers, testify, present evidence, and remain silent. We just want to make sure they're making an informed, intelligent decision before they plead out. And of course, pretrial is the time for the parties to exchange the discovery, police reports, and if they're not charged with a criminal offense, they can contact the prosecuting attorney. They don't need to be represented by an attorney, and Brandon and his subordinates usually offer them a plea offer. If you plead to one of these dog leash violations, I'll dismiss another dog leash violation, to offer them an option of pleading, bringing finality to the case rather than coming back for trial. The trial's for the time you bring your witnesses and evidence, as well as the prosecutor bring its witnesses and evidence to court to prove that you committed the infraction, violation, or crime, as well as you prove that you didn't. So you submit your evidence and testimony on the trial date. So, and sentencings occur after trial or after the judge receives the person's plea of guilty or no contest. The sentence depends on the facts and circumstances of the incident, as well as what the statute allows the judge to sentence that person to. For example, DUI has certain mandatory minimum requirements that need to be imposed, like a substance abuse assessment, right, or the 14-hour mandatory course, as well as a license revocation. So the judge always refers back to the sentencing guidelines in the statutory provision of that particular charge that that person was charged and convicted of prior to entering sentencing. We also hear from recommendations from the prosecutor and public defender as well, like what does this case or defendant warrant, or what they would request of the court for sentencing. So sentencing arguments are usually discussed with the court by the prosecutor and public defender, and it depends on what the court can sentence that person to, and of course not exceed the statutory authority. And did you want to chime in on any of those, or did you want to go on to who can charge?
I think you covered it.
Okay.
So so that question, someone from Duchess, you're asking who can institute the charges? Sounds like that's a question. The answer is just prosecutors. The charge, say you see the news reports that police charge someone. Well, yeah, that's true. They are charging them with a crime, but ultimate decision, it comes down to the prosecutor's office. And we have ethical obligations that we have to follow, and we have to follow our mission, which is to promote justice. So we weigh the evidence. We decide whether we can prove this case beyond a reasonable doubt, which is a very high standard. And then we look at whether justice will be served by prosecuting this person. And those are the guidelines that we follow when we make decisions of whether to charge or to not charge someone with a particular crime. So the police, the standard is probable cause, which is a lower standard to arrest someone versus what our burden is at trial, which is proof beyond any reasonable doubt. So we have different standards. So even though police may arrest someone, we may not charge them if we decide that we don't have enough evidence to prove that case beyond any reasonable doubt.
I think we touched upon a little about the difference between district and circuit court being misdemeanors and lower on the district court level, and jury trials at the circuit court level. Unfortunately, we discussed at this morning's meeting that Lānaʻi courts don't have jury room capability as of yet. So anyone that's charged with a misdemeanor who has who can make the choice of having his or her case heard before one judge or a jury, where you choose 12 members of the community, they would hear the facts and evidence about your case, and they would have to issue a unanimous verdict. Wouldn't have that option here in Lānaʻi. They would have to waive the jurisdiction and go to a jury courtroom courtroom in Wailuku. So maybe one day in the future, with the increase in population and the increase and the approval of the judicial position and staffing, and Mr. Ellison maybe could build a jury room capability here in Lānaʻi for the community, because it's important to bring justice to even the rural community. I also do civil proceedings. Those include landlord-tenant, small claims, TRO hearings, regular claims. The statute describes, and was just amended in 2014, any claim involving damages $40,000 or less can be filed in regular claims. If it's $5,000 or more, on a civil matter, you can ask to be heard on a jury level civil circuit court case. So that's the jurisdictional limits. Landlord-tenant, we hear a lot, and increasing now, especially in the rural communities. There's eviction proceedings, writ of possession, summary possession proceedings. Those are exclusive jurisdiction of the civil district court calendar of the judge. So I hear those every third Tuesday of the month, in addition to traffic criminal here in Lānaʻi, but every Monday in Wailuku, and trials as well. But the Judiciary has partnered up with other agencies out there, including Legal Aid, as well as Maui County Bar Association, in creating a STAY program. The acronym STAY, I should pass it out and I can email it to you, but to pass out here in addition to all those good flyers on the table back there. STAY stands for Steps to Avoiding Eviction. And if you have any comparable Lānaʻi housing agencies that help or assist those people that may be faced with eviction, please let me know. We can tailor that flyer. I had to go up through the whole chain of command to getting approval of publication of that flyer. But Section 8, County of Maui, they liked it. They handed it out with their clients and those that are looking to. But it gives helpful advice in terms of pay your rent on time, have a written agreement, and also gives you important information on those housing agencies that will be willing to assist those that are faced with eviction. But those are increased cases that we're seeing, at least on the landlord-tenant and eviction. A lot of landlord-tenant cases deal with the return of the security deposit or not paying rent. So we hear all kinds of different disputes regarding that. And like family court, Maui Mediation Services does assist in alternative dispute resolutions on our civil calendar. We have many cases to go through on those respective days. So if we have a qualified mediator in the courtroom, we like to refer them to mediators to see if they can handle a quick mediation session there, put the terms of the agreement on the record, and dismiss claims. Or can we set it for a status date down the road, allow mediation or ho'oponopono to occur, and if there's agreement, no need to come back, or if the dispute still remains, we can set the trial date. But the court, because there's so many cases, so few time in the civil calendar, they likes and welcomes alternative dispute resolution to resolve disputes rather than having to go to trial on a civil matter. And I advise the litigants in small claims court, the court's decision is final. There is no right to an appeal, so the court always likes to refer them to mediation or direct negotiations with each other prior to a court ruling, and then you'd be happy with their ruling and you have no recourse once the judge rules in small claims court. Okay, and Brandon discussed a little bit about the probable cause evidence, affidavits, and burdens of proof. The only thing that you forgot to mention was civil burdens of proof. It's preponderance of the evidence. So it goes probable cause. It talks about reasonable suspicion that a crime may be committed by that person. Then it goes up the next level, preponderance of evidence, right? More likely than not, than clear and convincing, then beyond the reasonable doubt. Taking me back to law school. So there's different standards of proof for different types of cases. And the highest being with criminal cases, because you're dealing with someone's life, liberty, property, constitutional rights. So you have to have that high burden of proof. You know you're innocent to proving guilty, right? So.
And district court is just like circuit court, bound by the rules of evidence. And in particular for district court cases, there's a lot of foundation needs to be laid. We can't just go in and have an officer say, I used my laser gun, he was going 75. It's our burden as a state to prove that he was trained appropriately, he used the gun, he operated in accordance with the manufacturer's recommendations, he tested it properly. And that's all our burden. The defendant can just sit there and say nothing, and doesn't have to say anything, and that wouldn't be held against him whatsoever, because he's innocent until proven guilty. And if the state doesn't meet their burden beyond a reasonable doubt, he wouldn't be convicted.
And we touched briefly about sentencing guidelines, and one thing I did want to mention with pre-sentence reports, everyone under the age of 21 has a right to it before the judge issues sentence. Usually after we take a plea, hear the recommendation, and we sentence right there. But if the judge hears that the person is 21 or younger, excuse me, we have to go through this colloquy with them. You have a right to a pre-sentence investigation report. It is your decision to waive or not. If you like this report to be done, someone from Maui Intake Service Center will come and interview, do a write-up to the judge about your history, background, career, education. Excuse me. And that person would make the recommendation to the court what the sentence should be. So everyone under the age of 21 has that right to have a pre-sentencing report. And there have been a few occasions when there's no agreement per sentence, or the judge didn't want to follow the agreement of counsel. And so the judge ordered a report to get a report from that agency to the recommended sentence. Did you want to comment on drug court?
I think.
Or deferral? Deferral's a good one for you to comment on.
Yeah, drug court is not a district court thing. Judge Pullman might be able to talk more about drug court. But just a deferral, is this an option that people have prior to going to trial? It's called deferred acceptance and no contest plea. And it gives you a chance, if you qualify, and some offenses qualify, it gives you a chance to keep the offense off your record if you don't want a criminal conviction. And essentially you would go on probation, you would complete the elements of the probation. It might be alcohol abuse treatment, or pay a fine or restitution, or go through anger management, or whatever it is related to that type of offense. And upon completion of that probation, as long as you're in compliance, you can go to the court and ask them to dismiss that charge. And then once that charge is dismissed, then you have an option to go to the Attorney General's office and actually get the charge and arrest expunged from your record. So if you ever have a job application, you'd be able to say, have you ever been convicted of a crime? You'd be able to check no. That's just an option that some people have on certain types of cases. Again, it all falls under our mission to promote justice, and whether they qualify for that option.
And the public defender likes to assist those, especially those that don't have a criminal record, and advise them of this option, because it's a good opportunity to have a free and clear arrest and conviction record, especially if you don't have, and you never used a DANK before, but that's an option to talk about if you're coming into problems with the law and don't want a criminal conviction on your record. Drug court, we don't have drug court here for district court, but I know Judge Bisson and Judge Cardoza are the primary judges that do drug court for circuit court level crimes. I know it's a tough program that requires a lot of court appearances, maybe some treatment, and allows maybe to have the conviction off your record if you comply with the terms and conditions of the drug court. And maybe once or twice a year they have a drug court graduation that judges attend in Judge Cardoza's, and they celebrate the accomplishments of those that fought their addiction, if any, and or crime that they're faced with, and celebrating their moving forward on in life without and graduating from drug court. So maybe it'll come to district court one day, but we see just the petty misdemeanor level drug offenses, including DUIs and PDD-3, but we don't have drug court yet in district court, unfortunately.
Yeah, the theory is to rehabilitate, so a lot of times these thefts and these type of offenses are all tied to drugs. And so if you can address the underlying problem, rehabilitate the person, then it gives them a chance to move on with their life and they don't have the felony conviction on their record.
Okay, and The last bullet point, we talked briefly about the teleconferencing from Lānaʻi for circuit court cases. Judge Pullman mentioned earlier that Judge Cardoza said he's all for it, especially if it doesn't involve an evidentiary hearing or a trial. The rules of court allow for it as well. But unless it goes to trial, you have to be in the venue or district that the allegation took place as well. So, and the importance of being present is not only serve the community, but be able to cross-examine the witnesses fairly and hear them and see their demeanor. But Judge Cardoza, at least for circuit court cases that are not contested and non-evidentiary hearing and just pretrial or statuses, is all for teleconferencing to get out to the community.